Passage 17. Start. All concerned appear to have felt satisfied with the above quoted communication, as no one, including the respondent Pakistan Television Corporation and the two petitioners, never voiced any grievance nor agitated against the issuance of the above quoted directions. The two petitioners, however, claim to have been shocked by the issuance of a letter by the respondent Pakistan Electronic Media Regulatory Authority (PEMRA) dated 10/6/2011, whereby the above quoted letter dated 22/12/2010 was withdrawn, and it was to question the said subsequent letter dated 10/11/2011 that the petitioners felt compelled to approach this court through this petition for redress of their grievance. It was submitted that the impugned action conduct of the respondent PEMRA was a gross infringement of fundamental rights which stood guaranteed not only to the two petitioners but even to the public at large, that the same was an act calculated to cause inter alia huge unbearable financial losses to the two petitioners, that respondents number 3 to 5 were obliged not to infringe the copyrights of the two petitioners nor to allow infringement thereof by anyone else, and further that the impugned action appeared to be rooted in malice. Mr. Salman Akram Raja, the learned counsel for the PEMRA, who appeared on caveat, vehemently argued for the dismissal of this petition, contending that the above quoted communication dated December 22, 2010 had been unauthorizedly issued by the Regional Journal Manager (PEMRA), which was also violative of the relevant law regulating the subject, and it was for the said reasons that the same had been withdrawn. On our query, the learned advocate Supreme Court submitted that a letter had been issued to the said General Manager on 11/1/2011 seeking his explanation about issuance of the said communication. A copy of the said letter was placed on our record, which had commanded the said manager to submit his explanation within 7 days. Today, however, happens to be the 13th day, but neither the explanation submitted by the said regional manager was placed before us, nor could it be shown that any disciplinary action had been initiated against him for issuing the said communication, which was being vociferously condemned by the learned counsel as a display of gross illegality and misconduct on the part of the said officer, Mr. Raza Kazim, the learned senior advocate Supreme Court, appearing for the respondent PTV, submitted that the said letter dated 22/12/2010 had been issued by a regional office of the PEMRA and not by the PEMRA itself. He, however, conceded that petitioner number 1 had been granted the broadcasting rights for airing the ICC Cricket World Cup 2011, but added that the respondent PTV had the terrestrial broadcasting rights of the said tournament. He added that once the PTV broadcasted the event exercising its said terrestrial rights, then it had no control over the same, which broadcast could then be caught up by any person, including the cable operators, which operators could then air the same, and that the said operators were under the control of PEMRA and not of the PTV. He, however, further conceded on our query that the PTV had not raised any grievance against the above mentioned letter dated 22/12/2010, nor had It approached any forum, including the Pemra, to agitate against the same or for its recall. Full stop and close.